Yo, what's poppin', people? Your boy Snacks is back in the building with another banger. And you know how we do before we get started. Go ahead and do your boy a solid and hit that like button, hit that subscribe button, and please do not forget to turn your post notification bell on so you'll know when your boy is going live or dropping his heat. And y'all know how we do, man. We handle our business. And we got another article from our boy Brent Shortenbauer about we got an update on Shiloh's bankruptcy case. And for those who don't know, who are just now first time viewers and just learning about the case, just go to the playlist on my channel and you can catch it from the top because we've been covering this since it started last year, since it started being published last year. So we've covered everything up to now. And we got an update on yesterday, which was Thursday, the 14th. But you probably won't get this until next week because I won't let it go before a game day. I never have and I never will. So game day is tomorrow. Colorado plays Utah, which we already know that's a W. That's a big W. You know, I already put my predictions out there, 45, 17, 24, 49, something like that. You know, Colorado will get the W. Utah is good, but they ain't that damn good. Their offense is depleted. Defense is strong. They got the best defense in the Big 12, but should carve them up real easy. Should throw for about 350, 400. Travis touchdown, LeJounte touchdown. Hope Jimmy play. He get a touchdown. Will a touchdown. And then one of the running backs a touchdown. You know, even Shador a touchdown. So that should cover everything. That should put about 49 on the board. 40, 50, half 100, 60. They might run it up with Utah because, you know, everybody talking about how stout their defense is. But I keep telling y'all, Colorado got the best offense in the Big 12. It's damn near unstoppable. Even if they play bad, they still should win. But as we know, let's get into this joint about Shilo and this bankruptcy case, dog. Bankruptcy judge questioned Shilo Sanders for his no-show at the previous trial. Colorado safety, son of Coach Deion Sanders, is trying to discharge more than $11 million in debt stemming from a trial that he didn't contest. As you can see, this thing was put up on the 14th, and which was yesterday. And we know we've been on this thing, man, and Shilo been trying to get this thing thrown out, get the debt discharged. You know, as the last one, the judge was like, I don't know, we gonna see. Let's do some more investigations, but let's see what we got right now. Denver, the federal judge overseeing the bankruptcy case of Colorado football player Shilo Sanders, asked several questions last week about the critical issue in this whole stage saga. Why did Shilo Sanders not show up for his trial in Texas in 2022 after being sued by the security guard at his school in Texas? His no-show at the trial led to an $11.89 million default judgment against him, which in turn led to him filing for bankruptcy last year. If he had shown up or hired an attorney to help, he could have defended himself or negotiated a settlement to avoid the worst case outcome. He's instead had to resort to trying to get the debt erased in the bankruptcy case. The bankruptcy judge held a court hearing in the case last week. Quote, it was the default trial. My client did not have a chance to share his side of the story, Shiloh's attorney Victor Vital told the judge in the hearing. He didn't have a chance, Judge. Michael Romero asks, he intentionally chose not to show up. I don't agree with that, Your Honor, said Vital. And let's see. Sanders is the son of Colorado coach Deion Sanders. What he did or did not do in that Texas court case now has him in a financial jam that led to an inspection of his apartment and a pursuit for more information about his property, which is true. Like I said, the judge ordered an investigation, wanted to see where the money was, who was getting the money, what companies was getting the money, because Shilo pays himself through his company, so they wanted to know where the NIL deal was, how much they were, who was doing what, and where the money was going. And they wanted to see if he was hiding any money. That is yet to be determined. So we waiting on that, because they were supposed to do a forensic audit of all of Shiloh's money. And the judge said, no, that was going too deep. We don't want to involve too many third parties in all this. Let's just do it ourselves. So they still doing that. How it got to this point. Shilo Sanders, now 24, filed for Chapter 7 bankruptcy last year in an effort to discharge the debt he owes to John Darjean, a former security guard at his school in Dallas. Darjean accused Sanders of throwing an elbow into his upper chest area and punching him when Darjean tried to confiscate his phone at school in 2015 when Shilo was 15 years old. As a result of the alleged assault, Darjean claimed he suffered a severe and permanent injuries to his spine, leaving him incontinent. Now, y'all remember, Darjean had already had some injuries from playing baseball and had surgery on his back and some other crap. Darjean sued Shilo and his parents for damages in 2016, a civil lawsuit in Texas that they fought for years, including in deposition testimony by Shilo and counterclaims filed by Shilo against Darjean. Deion and Shilo Sanders described Darjean as the aggressor, not Shilo. But after both parents were dropped from the case by early 2019, Shilo went off to college in South Carolina that year as a sole remaining defendant in the case at age 19. Yeah, so at the beginning, everybody was in the case, Shilo and both his parents. And when Shilo became an adult at the age of 18, Deion and then his current wife were dropped, and his mom were dropped off of the case, leaving Shilo as the lone defendant on the case. There was no evidence he was aware of the trial. In 2020, he dropped his attorneys in the Texas Silver case and didn't hire new ones until long after the trial was over. His previous attorneys told the court in 2020 that they had been informed by the Sanders that he is unwilling or unable to continue funding the defense for this case. Trial notices later went to his email address and address in South Carolina after he had transferred to play football for his dad at Jackson State. According to the court records, if he had kept an attorney to receive notices for him, he wouldn't have missed it. Did he notify the court of his whereabouts at all so he could receive notices of the trial? Judge Romero asked. I'm not aware of that, Vital said. I know the mailings went to him that were returned undelivered. It is his duty to notify the court when he moves so he can receive official notices. Is it not? The judge asked. It is incumbent upon a party to notify the court of his whereabouts, Vital said. What I will say, Your Honor, in response to what you're asking, there's no evidence he was aware of the trial. No show leads to default judgment against Shilo, which is true. So when the notices went out, Shilo had left South Carolina and went to Jackson to play for Deion. So the notices went to his South Carolina email, which was probably Shilo Sanders, blah, 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 at the University of South Carolina, So he didn't get none of that. I don't think, unless he forwarded them and they forwarded. I doubt it, because they probably just closed their email account and went on about their business. The Texas case instead went to trial without him in 2022, where the judge considered evidence in the case, 76 exhibits, and 6 witnesses, according to Darjean's attorney, Ori Raphael. The judge then issued an $11.89 million default judgment against Sanders, along with findings of fact and conclusion of law. Now remember what I told y'all in the last video. Words on court documents mean something. And you can leave a word or a few words out of a document, and that document means probably nothing or less than what it was intended to mean. Shilo. So these words, that finding of fact and the conclusion of law, that's what it means. They just found it, that the facts of the trial or the exhibits that they sent out or they showed in court were findings of fact, because Shilo wasn't there to defend himself. And so the conclusion of the law of the trial was a default judgment for the defendant for $11.89 million. And this is where we are. Shilo was in his teens when much of the litigation happened, and just 22 when it went to trial. I don't know many early 20s individuals who would be well versed in understanding the consequences of their actions in a legal proceeding, said the attorney Kate Buck of the firm McCarter and English, who is not involved in this case but has worked on bankruptcy and sports cases. She writes, kids in their 20s and they don't know nothing about going to court and doing all that. Nobody care. They trying to live their best life. Well, she said, I just wonder where it went wrong, that he didn't have the guidance to understand the importance of his participation in trial and to have representation all along the way, Buck said. There may have been any number of reasons that things went the way they did, but it doesn't seem sort of like a parade of horribles, in the sense that something he did as a minor continued to follow him into adulthood. That's correct. This shit been going on for 10 years. Vital told the judge he only knows that notices were returned as undeliverable. I'm not aware of what he did or did not do, Vital told Romero. Shilo himself said in July that everybody is going to know the truth about everything. He said that at a press conference after a game they won, sitting beside his dad. That's after he came back from his injury and played bad in that doggone game. But declined to get more specific. The University of Colorado said he and his father would not comment further on the pending case. Was he willful or malicious in 2015? The judgment and findings from the Texas court left no doubt about who was found responsible for Darjean's injuries. The court finds that John Darjean's injuries and damages were a foreseeable consequence of the physical assault perpetrated by Shilo Sanders, said the findings and conclusions signed by a judge in Texas in April 2022. Well, I can't get that out. A big question about that now is what to read into the judgment and findings. Just like I said, we got questions about that. Because remember, words mean something when it comes to the law. Darjean's attorney have asked the judge to rule in a summary judgment that the debt is not dischargeable under the law because it stems from a willful and malicious injury from the debtor, a specific exception to discharge the bankruptcy law. Now those are the words that were missing from that judgment. Now, if in that final judgment and on that paper, the judge would have put in there willful and malicious, then this was been settled. This would have been settled law. Wouldn't have been no retrial. Wouldn't have been none of this. It would have been done and over with. But since that wasn't put on, that left the door open for Shilo to try to get this case thrown out or retried since he wasn't there. But those exact words, see that? But those exact words did not appear in the default judgment and findings against Shilo Sanders, leading the judge to question whether there might need to be a retrial to answer that question. Was Sanders acting willfully and maliciously then? This relates to his state of mind at the time. Raphael told the judge Shilo already had a chance to defend himself in court and shouldn't be allowed to relitigate what happened in 2015. He wants his client to collect on all his debt. Yeah, see, Darjean's attorney just like, look, dude, we done been through this already. We went to trial. We had a judgment. Shilo didn't show up. We just want to get our money. We ain't trying to do all this again. But Shilo like, bro, it ain't that easy. The lawsuit carried on for 6 years, Raphael told the judge. There was substantial participation by Mr. Sanders. He filed 4 amended answers, multiple counterclaims. He was very involved. He quit the game after not showing up for trial. Shilo Sanders also did not appeal the Texas judgment. He had the chance for 6 years to raise it, to come to trial and do it. Raphael told the judge. The game started. He got on the field. He left before the whistle blew. He quit the game. Wow. The judge poked fun at the football analogy. It's not appropriate to bring in a football analogy in this particular instance, the judge said. The judge could rule on that issue in coming weeks. The judge sides with Darjean. Shilo would be on the hook to pay back the debt, including from future earnings. If the judge sides with Shilo, the issue could go to trial about whether he acted willfully and maliciously in 2015. Shilo Sanders, a starting safety for Colorado, was not required to attend the hearing last week and did not. His team is 7-2 this season and plays Utah on Saturday in Boulder. That is correct. And they're going to win that game and be 8-2 and be two games away from playing in the Big 12 championship. And after they beat Kansas, the next Saturday, they'll be 9-2 and 1 game away from stumping Oklahoma State in the face. But that's where we at. So now, judge want to be like, hey, we want to relitigate this thing or not. They're going to figure it out, and then we're going to go from there. They probably going to relitigate it. That's what it looks like that judge is leaning toward. He's sounding more like, hey, this man didn't get a chance to defend himself. I know y'all brought all that stuff, and then he looked at the case and was like, dude, you was hurt before all this happened. You played baseball, you done had back surgeries. Now you trying to blame a 15-year-old for hitting you with an elbow, and now he done messed up your spine and your neck and all this, and you permanently injured, and you trying to say he did all that off of 1 elbow? Come on, dog. But we gonna see what the judge gonna say. But y'all let me know. Y'all hit the like button. Leave your comments in the comment section. Let me know what y'all think about the new judge, what the judge got to say, and how y'all think this is gonna unfold. What the judge gonna do? We gonna retry this thing? Because remember, like I said, words mean something. And those words were not on that document from Texas. So I think the judge gonna retry this thing, and he want to hear both sides so he can give a ruling. Shilo still might lose, but it won't be $11.89 million. That I promise you. But anyway, man, we're gonna get out of here. Y'all make sure y'all hit the like button, hit the subscribe button, do what you do. We out of here, man. Peace.